No court can take cognizance of an offence punishable under Chapter 21 of IPC except upon a complaint made by some person aggrieved by the offence, provided without leave of the court, some other person may make a complaint on his or her behalf. Options: if such a person is an idiot or lunatic, if such a person is under the age of 18 years, if such a person is a woman who according to the local customs and manners ought not to compelled to appear in public, and option 4, all of the above. Here the correct answer is option 4, all of the above. Chapter 21 of IPC is related to defamation. Section 499 defines defamation, and section 500 is related to punishment of defamation. Section 501 is related to printing or engraving matter known to be defamatory. Section 502 related to the sale of printed or engraved substance containing defamatory matter. Now let us see the question number 27. X is facing a trial for the murder of an advocate. None of the advocates he wishes to engage to accept in the brief. X thus wants his trial to be transferred from the Sessions Court, the subordinate A High Court, to the Sessions Court subordinate to B High Court. Options: X should file a petition before A High Court, X should file a petition before B High Court, and X should file a petition before the Supreme Court, and option 4, any of the above. Correct answer is option 3, X should file a petition before the Supreme Court. Question number 28. In Delhi, offences under section 272 to 276 of IPC are triable by the Court of Sessions only, the Court of Chief Metropolitan Magistrate only, the Court of Magistrate of First Class only, and the Court of any magistrate. Correct answer is option 4, the Court of any magistrate. Section 272 to 276 of IPC comes under the Chapter 15 of IPC, that is of offence affecting the public health, safety, convenience, decency and morals. Section 272 is related to adulteration of food or drink intended for sale, and section 273 is related to sale of noxious food or drink, and section 274 is related to adulteration of drinks, and section 275 sale of adulterated drugs, section 276 sale of drug as a different drug or preparation. Now let us see the question number 29. Culpable homicide is not murder if the offender being a public servant aiding a public service acting for the advertisement of public justice exceeds the powers given to him by law and cause death by doing an act which he in good faith believes to be lawful and necessary for the due discharge of his duty as such public servant. Option 2, without ill will towards the person whose death is caused. Option 3, both first and second, and option 4, either 1 or 2. Correct answer is option 3, both 1 and 2. Question number 30. An offence, though compoundable with the leave of the court, cannot be compounded under section 320 CRPC if the person who would be competent to compound it is dead, if the person who would otherwise be competent to compound is under the age of 18 years or an idiot or lunatic, and option 3, if the accused is by reason of previous conviction liable to enhanced punishment, and option 4, all of the above. Here the correct answer is option 3, if the accused is by reason of a previous conviction liable to enhanced punishment. Section 320 CRPC talks about the compounding of offence. Now let us see the question number 31. In which of the following decisions Supreme Court pronounced that a victim must seek legal appeal against an order passed by the court acquitting the accused under proviso through section 372 CRPC? Options are Satyapal Singh versus State of Madhya Pradesh, S. Sundaram Pillai versus V.R. Pattabirman, and option 3, Dwarka Prasad versus Dwarka Das Sarraf 1976, and option 4, none of the above. Here the correct answer is option 1, Satyapal Singh versus State of Madhya Pradesh, GAT 2015, SC 281. Section 372 of CRPC talks about that no appeal to lie unless otherwise provided. No appeal shall lie from any judgment or order of a criminal court except as provided for by this code or any other law for the time being in force. Now let us see the question number 32. Under the Code of Criminal Procedure 1973, pre-charge of evidence is recorded in all private complaints, all complaint cases, case instituted on police report, warrant case instituted otherwise than on a police report. Here the correct answer is option 4, warrant cases instituted otherwise than on police report. Question number 33. Statement under section 164 CRPC 1973 can be recorded before Deputy Commissioner of the Police, Station House Officer, any metropolitan magistrate or judicial magistrate, none of the above. Correct answer is option 3, any metropolitan magistrate or judicial magistrate. Section 164 CRPC is related to recording of confession of statements. Question number 34. Statement under section 313 CRPC can be recorded only in appeals at any stage without previously warning the accused when the court considers it necessary after the prosecution witness have examined, and option 4 under 2nd and 3rd. Here the correct answer is option 4 under 2nd and 3rd. Section 313 of CRPC is related to the power to examine accused. Question number 35. When a court of session passed a sentence of death, the accused is immediately hanged. The proceedings are sent to Supreme Court for confirmation. The proceedings are sent to High Court for confirmation. None of the above. Correct answer is option 3. The proceedings are sent to High Court for confirmation. Question number 36. When a metropolitan magistrate passes a sentence of imprisonment for 3 months, the appeal shall lie before. In the case of 3 months, there will be no appeal. So the option 4 is correct, nowhere. Grievous hurt is defined in under section 320 IPC include dislocation of tooth, fracture of a bone, both the above, none of the above. Correct answer is both of the above. Grievous hurts include dislocation of a tooth and fracture of a bone. Now let us see the question number 38. The offence of attempting to commit suicide under section 309 IPC is ultra-vires the constitution, carries on conviction, minimum sentence of 10 years, triable by court of session, and option 4 none of the above. Correct answer is option 4 none of the above. 39. A dashes B to the ground and fraudulently takes out his money from his pocket without his consent. A has committed which offence? A has committed robbery. A appears as a witness before a judge trying a case who does not believe in his disposition and says that A has perjured himself. A moved by sudden passion by the words of the judge and kills him. Here A has committed an offence. And option second, A has committed murder. And option third, A has committed culpable homicides amounting to murder. And option 4, none of the above. Here A has definitely committed the offence, but this is not the satisfactory answer. That therefore the satisfactory answer is option second, A has committed murder. Question number 41. A fires a gun at a wedding reception leading to the death of one of the guests. Whom did he not intend to hurt? A has committed murder. A did not intend killing the guest and thus has committed no offence. A has committed culpable homicide not amounting to murder. None of the above. Correct answer is option third. A has committed culpable homicide not amounting to murder. Question number 42. Under section 142 subsection 2 of Negotiable Instrument Act 1881 was inserted by the Negotiable Instruments Amendment Act 2015 made effective from 15 June 2015. The holder of a check that has been dishonored when delivered for collection through an account can file complaint only. Option first, before the magistrate in whose jurisdiction the drawer of the check resides or carries on business. And option second, before the magistrate in whose jurisdiction the drawee bank is located. And option third, before a magistrate in whose jurisdiction the payee resides and tendered the check for payment. And option 4, before a payment within whose jurisdiction the branch of the bank where the payee or holder in due course as a case may be maintains the account instituted. Correct answer is option 4, before a magistrate within whose jurisdiction the branch of the bank where the payee or holder in due course as the case may be maintained the account is situated. Question number 43. Which of the following statement is correct? A is not liable for prosecution in terms of section 141 of the Negotiable Instrument Act if he is A. nominated as director by virtue of his holding an office for or employment in the central government. Option B. nominated as director by virtue of his holding an office or employment in state government. And option C. nominated as director by virtue of his holding an office or employment in a financial corporation owned or controlled by the central government. And option D. nominated as director by virtue of his holding an office or employment in a financial corporation owned or controlled by the state government. Here the correct answer is option third, A or B or C or D. Section 141 of Negotiable Instrument Act deals with the offence by companies. Now let us see the question number 44. The amount maintained in a check figures in rupees 2,15,000, but in words it stated rupees 2,50,000. Which one of the following consequences ensue? Here the check will be taken to be for rupees 2,50,000. Question number 45. Ramesh, who has an account with a branch of the State Bank of India in Dubai, draws a check on SBI Dubai in favor of Abdullah, a resident of Dubai. The check is signed in Kochi and handed over to Abdullah in Kochi. The check, when presented by Abdullah through his bank to the SBI Dubai, is dishonored. The remedy available to Abdullah is to proceed against Ramesh in accordance with the law applicable in Dubai as regards dishonor of check. To follow the procedure under section 138 of Negotiable Instrument Act 1881, to approach the Government of India for permission to file a complaint against Ramesh, to proceed against the State Bank of India in the Court of Magistrate in India within whose jurisdiction its head office is located. Correct answer is option 1. To proceed against Ramesh in accordance with the law applicable to Dubai as regards dishonors of check. Question number 46. The number of seats allocated to Delhi in Rajya Sabha in terms of the 4th schedule to the Constitution is 3. Question number 47. When a question arises whether a bill is a money bill or not, the decision of which of the following authorities shall be final? Here the fourth option, the decision of the Speaker of the Lok Sabha will be the final to decide whether a bill is a money bill or not. Now let's see the question number 48. Which of the following is described as an offence in the Constitution of India? Option A. Preventively detaining a person in contravention of Article 22. A citizen of India accepting a title from a foreign state under Article 18. Trafficking in human beings and beggar under Article 21. Enforcement of disability arising out of untouchability Article 17. Here the correct answer is option 4, that is C and D. Trafficking in human beings and beggar under Article 21, enforcement of disability arising out of the untouchability under Article 17. Question number 49. The minimum age for being President of India is option 4, that is 35 years, the correct answer. As of date, in terms of the first schedule to the Constitution, India has, here the options are 26 states, 7 union territories, 27 states, 6 union territories, 29 states and 7 union territories, 30 states and 6 union territories. And the given options, no option is correct, because at present India has 28 states plus 8 union territories. Following 8 union territories are Andaman and Nicobar, Dadra and Nagar Haveli and Daman and Diu, third Jammu and Kashmir, fourth Lakshadweep, fifth Chandigarh, sixth Delhi National Capital Territory region, seventh Ladakh and eighth Puducherry. Therefore, total 8 UTs and total 28 states are there in India.